DUI with injury is also similar to a simple misdemeanor DUI in terms of the first two basic elements that are required. First, it has to be shown that you were, of course, driving a motor vehicle and that you were either driving with a blood alcohol level of 0.08 or higher, or that you were driving under the influence of alcohol. In order to elevate a standard DUI into a DUI with injury, it must also be shown that while you were driving, you either neglected to do some kind of legal duty that you were required to do, or you committed some kind of unlawful act. And that unlawful act or neglect of duty is the reason or cause of someone else's injury. Now, an example of an illegal act can be literally anything. It could be speeding, it could be running a stop sign or swerving lanes. However, the law is clear that there actually is not a requirement that this illegal act that you do actually be some kind of vehicle code violation. It could be something as simple as swerving within your own lane that could lead to the illegal act. Now, the second aspect of it is failing to perform a legal duty. This can be something as simple as driving without a seatbelt or driving without a car seat for a minor in the back seat. This would be a legal duty that you are neglecting to do that leads to the injury. In addition to this accident or this failure to act, you also then subsequently cause an injury to another person. This means that if you're driving by yourself and you hurt yourself while driving under the influence, you could not be liable then for a DUI with injury since you were the injured party and you were the driver. It requires a second person, whether someone in your car or a passenger or driver in another vehicle, to be injured while you were driving. What's crucial here is that you have to be the person responsible for either neglecting the legal duty or committing the unlawful act that caused the accident. If, for example, you were driving under the influence and an accident happens, it's not enough to simply say that the accident happened because you were drunk. It has to be something else. An example would be if you were driving under the influence and you're stopped at a red light and then your light turns green and you go through the intersection and a sober second driver T-bones your vehicle. Now, at this point, you were driving under the influence, but if they hurt themselves in that accident, you would not be liable because you did not cause the injury. They did. Now, a DUI with injury is a wobbler offense, meaning that you can be charged with this as a misdemeanor or a felony violation. If you were to be charged with and convicted of this charge as a misdemeanor, you could go to county jail for up to 1 year. If you are charged and convicted of this crime as a felony, you could be sent to state prison for upwards of 2, 3, or 4 years, with a requirement that you serve at least 50% of that time. Now, in addition to this, if you also cause a great bodily injury, you could also receive a 3-year enhancement, making your case now a strike on your record and sending you to state prison for 3 additional years on top of what you would already receive from your felony DUI with injury. In addition to these penalties, you can also have to take a DUI class for up to 18 months, pay hefty fines and fees, as well as restitution to the victim if they are injured, and you can lose your driving privileges for up to 5 years. Now, there are many defenses to a DUI with injury case. For example, a violation of your rights if police pull you over for no good reason, or if you are arrested and the police are in violation of your Fourth Amendment rights, then that is an issue and a defense that you can use. In addition to this, in many of the cases that I've personally handled, many times the police fail to determine what illegal act or unlawful duty you committed that caused the accident and the injury. If those elements are missing, then this is just simply a DUI. Despite the fact the person was injured, unless they can show that you were actually at fault for the injury, you cannot be charged with a DUI with injury. Now, a DUI with injury, even as a misdemeanor, is much more serious than that of a standard DUI because it is a second person and that second person was hurt. You have to have the understanding that you cannot expect this to be a simple slap on the wrist or something where there will be no repercussions. That is why it's important to hire the right DUI attorney to help you. It can be the difference between you receiving community service and probation or you going to state prison for several years and receiving a strike on your record. Now, call the Inland Empire Criminal Defense today. I can help you.